Ladies and gentlemen, esteemed guests and participants, welcome to the inaugural session of our webinar series titled Israel-Palestine Conflict and the Future of Gaza. My name is Oluwaseun Teller, Head of the Future of Diplomacy at the University of Johannesburg's Institute for the Future of Knowledge. Over the next few weeks, we'll embark on a journey of understanding, dialogue, and reflection on one of the most complex and enduring conflicts of our time. Today, we kickstart our series with a deep dive into the theme, Unpacking South Africa's role in the ongoing Israel-Palestine conflict. South Africa's historical trajectory, marked by a struggle against apartheid and subsequent transition to democracy, provides a unique lens through which we can examine the complexities of the Israel-Palestine conflict. We'll explore parallels, lessons learned, and the potential for constructive engagement in seeking solutions. In our subsequent session, titled Voices from the Divide, Understanding Israeli and Palestinian Perspectives on the Conflict, we shift our focus to the human dimension of the conflict by amplifying diverse voices from both sides. We aim to foster mutual understanding and dialogue. Through expert insights, we hope to shed light on the lived experiences, aspirations, and grievances of Israelis and Palestinians alike. Throughout this series, we recognize the importance of respectful discourse, open-mindedness, and a commitment to seeking common ground. While the Israel-Palestine conflict may seem intractable at times, we believe that through informed dialogue and collective action, there is hope for a just and sustainable resolution. On behalf of the University of Johannesburg's Institute for the Future of Knowledge, I extend my gratitude to our esteemed panelists and participants for joining us on this journey. Your engagement and contributions are vital as we navigate through complex issues and strive towards a future of peace, dignity, and coexistence for all in the region. The chair of today's meeting is Professor Anthony van Nieuwkerk, based at the Tambo Mbeki African School of Public and International Affairs at the University of South Africa in Pretoria. Without further ado, let us delve into our first session as we explore South Africa's role in the Israel-Palestine conflict and its implications for the future of Gaza. Chair, you have the floor.
Thank you. I'll remain online for my opening remarks, and when I hand over to the panel, then I'll go to sound only. The title of this first round is Unpacking, or Examining South Africa's Role in the Ongoing Israel-Palestine Conflict. Indeed, it's a difficult topic to discuss. I'm very happy that we've got a very strong panel that will begin to open up some perspectives for us. Allow me just in a few minutes to give a bit of a context and a background before I introduce the panel and then hand over to them. I want to start by saying that the people of South Africa, Israel, and Palestine share a long and complex history. Most South Africans understand and sympathize with resistance against occupation in the struggle for self-determination, such as Palestine or the Sahrawi Republic, both of which have been ongoing for many years. And paradoxically, this might be the reason for South Africans to assist both Israelis and Palestinians in the quest for justice and security. Recall where we come from. The Balfour Declaration of 1917 and the contribution by Jan Smuts, and the role of Israel in its opposition to apartheid sanctions as it co-developed nuclear weapons, is a complex narrative between apartheid South Africa and apartheid Israel. South Africa is no longer an apartheid state. It managed its transformation or transition without a civil war, and its people have chosen the very challenging path to democratic consolidation. Indeed, this year, we celebrate 30 years of democracy with a progressive constitutional democracy and Bill of Rights enshrined with equality for all its citizens. The ruling ANC maintains close relations with the PLO. After the first democratic elections of 1994, South Africa established diplomatic relations with the state of Palestine on February 15, 1995. Former South African President Nelson Mandela had visited both Israel and Palestine and called for peace between both sides. But then what about Israel? Sadly, as Graham Harrison recently wrote, Israel is a country seemingly out of step with political time. Its people experiences neither peace nor security. Currently, Israeli affairs are managed by a coalition of ultra-conservative religious parties. Following the surprise attack by Hamas on Israel on October 7, 2023, the Israeli war cabinet, under the leadership of Benjamin Netanyahu, made it clear that it intends to prosecute a war in Gaza, to cleanse the area by turning Palestinians into a refugee people. As we speak, up to 100,000 Palestinians have died or are maimed in Israel's attempt to annihilate Hamas. Palestinian survivors in Gaza face a severe humanitarian crisis. The region is poised for a deepening of the conflict. Many Israelis who oppose the Netanyahu plan seek for ways out of the conflict. And indeed, international institutions and instruments can arrest war crimes and genocide, but they have been unable in creating conditions for such an immediate and permanent ceasefire. And why is that? On the one hand, the US, the UK, and France have vetoed UN Security Council resolutions on the matter. On the other, there has been overwhelming support for many UN General Assembly resolutions calling for an immediate ceasefire. Indeed, it is important, in my view, to recognize the heightened mobilization and solidarity across continents, religious sectors, women, youth, and trade unions for the Palestinian cause. This resultant UN paralysis, a symptom of a rapidly changing world order, brings new dynamism to the call for UN Security Council reform. What about the South African intervention? The Convention on the Prevention and Punishment of the Crime of Genocide of 1948 pronounced never again on atrocities of war. Articles 2 and 3 of the Genocide Convention is instructive, and South Africa, as a state party, made a strategic intervention at the International Court of Justice in its referral for provisional measures against the State of Israel in January 2024. And on January 26, the ICJ, in its judgment, ruled that the court finds there is a prima facie case of genocide against Israel, as Israel military actions fall under the purview of the Genocide Convention. The court gave Israel 1 month to take provisional measures to prevent acts of genocide and allow humanitarian aid in Gaza, and to report back to the court. But the war that continues is inconsistent with the ICJ ruling. Our panel will further examine this particular aspect. Is there a way forward? A colleague of mine, Dr. Pingla Udit, recently wrote that the road ahead necessitates an immediate and lasting ceasefire, release of all hostages, negotiations, and in particular, leadership for the people of Palestine to rebuild their broken lives. The Israeli people will need to choose a new government capable of negotiating with the Palestinians and with a vision of some kind of coexistence. There is an opportunity for Israel to build a democratic state. Israel, as part of a reconciliation process, should break down the walls and stop construction of settlements in the future. These are the challenges and the opportunities humanity needs to tackle in the quest for justice and security in the long-standing conflict between Israel and Palestine. How and to what extent can South Africans, the people and the government, make a contribution to realizing this quest? We have a very distinguished panel to help us make sense of South Africa's role. And they are in order of speaking. Zahir Laher, who is the Acting Deputy Director General for Global Governance and the Continental Agenda in the Department of International Relations and Cooperation. We just say DIRCO in Pretoria. Welcome, Zahir, and thanks for showing us your face. Nicole Fritz is going to speak second, and there she is in the red dress. She's an advisor or a counselor to Change Starts Now, which is the name of a new political formation based in Johannesburg. And Nicole will be followed by Otilia Mahunganitse. There she is, Head of Special Projects in the Office of the Director of the Institute for Security Studies, ISS, in Pretoria. Welcome, Otilia. And then last but not least, a colleague of many years standing for many of us, Professor John Stremlau, Department of International Relations. I don't know if I should say retired or emeritus professor, I'm not sure of the right title, at the University of Witwatersrand, Wits in Johannesburg. I was saying to the organizers that we have a panel that will give us a divergent set of views and analysis, and I think that is important, and we welcome that. I'm very happy to hand over to this very august panel, starting with Mr. Laher of DIRCO. So 15 minutes each. Will follow the speaking order, and hopefully at the end of your presentations, we will hear from the audience whether they have comments or questions, and we'll deal with that towards the end. Hopefully the entire session will finish before 7. I'm handing over to Zahir.
Thank you very much. I want to thank the University of Johannesburg's Institute for the Future of Knowledge for providing an opportunity for me to address you today on behalf of the Department of International Relations and Cooperation. This part of the two-part seminar is dedicated to unpacking South Africa's role in the ongoing Israeli-Palestinian conflict. We are convening at a time when, once again, the Middle East is engulfed in a myriad of conflicts, and, as is almost always the case, when there is conflict, it is innocent civilians that are most affected. Recent reports indicate that more civilians were killed in armed conflict over the last year than any other year for more than a decade. And civilians in the Middle East region make up the most of those lives lost. The South African government has reiterated its horror at the atrocities being committed in Palestine through the targeting of civilians, civilian infrastructure, UN premises, and other vulnerable targets. The actions that we are all witnessing daily by Israel are a violation of international law, including the UN Charter, the Geneva Convention and its protocols, and other international agreements and UN resolutions. In its attacks on and kidnapping of innocent civilians, Hamas has also violated international law. There can be no doubt that the illegal occupation of Palestine by Israel for several decades has led to bitter hatred and increased violence. South Africa has recognized the ongoing Nakba of the Palestinian people through Israel's colonization since 1948, which has systematically and forcibly dispossessed, displaced, and fragmented the Palestinian people, deliberately denying them the internationally recognized inalienable right to self-determination and the internationally recognized right of the return as refugees to their towns and villages in what is now known as the State of Israel. It is important to stress that the ultimate solution to the Israeli-Palestinian conflict is the establishment of two states, Palestine and Israel, living side by side in peace. The Palestinian state should be created along the 1967 borders with East Jerusalem as its capital and in line with relevant UN resolutions. For this two-state solution to materialize, a peace process initiated by the United Nations must commence urgently. However, if these negotiations were to commence and for there to be peace, As South Africa, we have reiterated that there must be a comprehensive end to the hostilities and a ceasefire. The killings must come to an end. The brazen bombing of hospitals, schools, residential areas, places of worship, and the denial of basic necessities must stop. The collective punishment that Israel is exacting on all Palestinian people is an affront that has existed for decades. The world has expressed horror, but has not acted effectively to save Palestinian lives. As we have consistently stressed, we cannot proclaim the importance of international law and the importance of the UN Charter in some situations and not in others, as if the rule of law only applies to a select few. For international law to be credible, it should be uniformly applied and not be treated selectively. The events of the last few months in Gaza have illustrated that Israel is acting contrary to its obligations in terms of the Genocide Convention. As a UN member state, and owing to South Africa's painful past experience of a system of apartheid, this impresses on us as member states and as a member state of the United Nations to take action in accordance with international law. South Africa thus opted to resort to international judicial mechanisms, including at the International Criminal Court and the International Court of Justice, to seek justice for the people of Palestine. As you're aware, on the 11th of January, lawyers representing the government of South Africa appeared before the International Court of Justice in a matter in which we are calling on the court to issue, which we did call on the court to issue provisional measures, including ordering Israel to stop its military action in Gaza, which we believed was necessary in this case to protect against further severe and irreparable harm to the rights of the Palestinian people. Several countries and regional organizations made public statements in support of South Africa's proceedings in this matter and indicated their desire to intervene in the proceedings after the hearing on provisional measures. We welcome this provision or this expression of support, and we've encouraged states to intervene in the merit stage of the proceedings. Of course, as Professor van Nieuwkerk indicated, the court issued its provisional decision on the 26th of January, where it indicated that they are plausible, that Israel is plausibly committing acts of genocide, and asked the state of Israel to report to the court on the steps it is taken to prevent these activities from occurring. Colleagues, the question of Palestine is one of the longest standing agenda items on the Security Council agenda. The Security Council is the international body entrusted by the UN Charter to maintain international peace and security. Unfortunately, the Council has not made any meaningful contributions towards a sustainable solution to this conflict. Since the events in October, the Security Council has considered 6 resolutions related to the current conflict in Gaza. However, only 2 resolutions have been adopted. These resolutions have, however, fallen short of calling for a humanitarian ceasefire. This again brings to the fore the issue of the need for reform of the Security Council and its decision-making, and accountability for the usage of the veto, which has prevented the Security Council from taking this meaningful action. For us, as South Africans, the occupied Palestinian territories and what occurs in these territories evoke unpleasant memories of life under apartheid rule. Having experienced apartheid in South Africa, the images we see in the West Bank and Gaza are reminiscent of the events that took place in South Africa. I think that is why we see so many South Africans finding solidarity across all walks of life with the Palestinian cause. Given our painful history, we cannot turn a blind eye to the discrimination and injustices that Palestinians are subject to under Israel's illegal occupation. The reports by Israeli non-governmental organizations, followed by those such as Human Rights Watch, Amnesty International, and others, are significant in raising global awareness of the apartheid-like conditions that Palestinians are subjected to. This has also emerged in the submissions by several UN member states in the recent ICJ hearing on the legality of the Israeli occupation. So I want to end here because I think this will be a very useful engagement and to hear from others, and we will be ready to engage with you in the Q&A part. I want to repeat what we have been stressing as South Africa. We've stressed this in the case of this particular matter, but also in the case of Ukraine and other conflicts, that war is never wise. When the use of force is utilized anywhere in the world, irrespective of whether it is lawful or unlawful, the laws of war must be applied, and most importantly, it is vital that civilians must be protected. So, Antonio, I'll stop there for now, and as I said, we'll be ready to engage in the Q&A part. Thank you very much.
Thank you, Zahir. I think you've given us the DIRCO perspective, government perspective. I really hope that the audience will engage. There are many outstanding issues that we want to address, including what is happening at the moment. I'm very happy to hand the microphone or the video or both, so to speak, to Nicole for your 15 minutes of input. Thank you.
Thanks very much. And can I just join Mr. Leher and extending my thanks to the University of Johannesburg and the Institute for the Future of Knowledge in extending the invitation to me to participate in today's events. I'm going to focus on South Africa's application to the International Court of Justice. Its application for provisional measures against Israel in terms of the Genocide Convention. On the 29th of December last year, South Africa filed a request for provisional measures against Israel before the International Court of Justice in terms of this Convention against Genocide. In its application, South Africa makes clear that it unequivocally condemns Hamas's actions of the 7th of October and its failure to release the hostages that were taken on the day. It explains that its foreign policy objective is the attainment of a durable peace between Israel and the state of Palestine. It's important to appreciate that the International Court of Justice, as the UN's highest judicial body, is concerned with establishing legal responsibilities as between states. So unlike the International Criminal Court, which South Africa has also approached in respect of the conflict between Israel and Gaza, it is not a forum which looks to ascertain responsibility of individuals. Rather, the ICJ is concerned with attributing legal responsibilities of states. In its provisional measures application, South Africa was not asking at that stage for the court to make a determination that Israel had committed, sanctioned, or incited genocide. Such a determination, which would be a determination of the merits, is many years away, and we need to only contrast this application with that which was brought by Gambia against Myanmar, also under the Convention against Genocide. That application was launched in 2018. The International Court of Justice has only asked for heads of argument to be submitted to it over this following year, 2024. And so one is not likely to have any hearing on the merits of that matter before 2025, so 7 years after the application was in fact filed. So the merits hearing actually do not offer any real prospect of relief within the confines of the conflict with any immediacy, but an application for provisional measures can do, and South Africa certainly sought such immediate relief, because the relief that it sought in terms of the provisional measures application was that Israel be ordered to cease its military operations in Gaza on the grounds that if South Africa's allegations of a commission of genocide by Israel are plausible, that there is a risk of irreparable harm if the court were not to act with urgency. I thought it might be helpful for us to for a moment, look at what is meant by the crime of genocide. Many will be familiar with this concept. It was originally conceptualized by a Jewish lawyer from Poland, Raphael Lemkin, to capture the horrors of the Nazi Holocaust that were perpetrated prior to and during World War II, while the Nuremberg military tribunals, which were held at the conclusion of the Second World War, did not use the term genocide in any of their judgments. The UN General Assembly recognized genocide as a crime under international law in 1946, so one of its very first acts. And countries concluded the Genocide Convention in 1948. Interesting to note, and this was brought to the fore in South Africa's application, is that Israel became party, was one of the first founding members of the Genocide Convention in 1948, so at the time of Israel's founding. And then, in fact, democratic South Africa sought, as one of its first steps post-1994, to become a party to the Genocide Convention. What is defining about the legal definition of genocide is not the numbers killed or the types of atrocities involved, although very much in the public imagination, that is what is defining about the concept of genocide. But legally, what is defining is this specific intent requirement referred to as a dolus specialis. It's, in terms of the definition, an intent to destroy, in whole or in part, a national, racial, ethnic, or religious group. South Africa's application focused very much on the rights of the Palestinians not to be targeted with the intent of destroying them in whole or in part as a group. South Africa's application to the ICJ was novel in that the International Court of Justice is not generally the first forum to which states turn in resolving matters of international peace, security, or humanitarian crisis. Generally, that would be the UN Security Council, which is understood to be the UN's highest decision-making body. But as Mr. Leher has already indicated, that body was essentially paralyzed given US support for Israel. So several resolutions which were put to it, which sought to secure a ceasefire, were essentially defeated by the use of the veto. This is not obviously the first time that the UN Security Council has been paralyzed. We've seen it paralyzed too in respect of the conflict between Russia and Ukraine. There, the veto being utilized by Russia. Interesting in the case of the conflict and the atrocities that are being perpetrated in Gaza by Israel, we saw the UN General Assembly, which is seen as essentially the parliament of the UN, pass a resolution for a ceasefire overwhelmingly in favor of such a ceasefire, 153 votes in favor, 10 against, and 23 abstentions. Unfortunately, though, UN General Assembly resolutions are not binding in nature. And I think it was recognizing the realpolitik, the fact that there would be no relief for the people of Gaza, either at the Security Council or at the General Assembly, that I think compelled South Africa to then approach the International Court of Justice. The hearings, as you've already heard, on provisional measures happened on January the 11th and on the 12th, and very shortly thereafter, on the 26th of January, and this is typical for the International Criminal Court. When it is approached for provisional measures, it generally hands them down with some immediacy. On the 26th of January, the International Court of Justice handed down its findings, and essentially it upheld South Africa's application. It did not issue an order that Israel should cease its military operations in Gaza, and whilst it didn't give any a rationale for why it didn't do so, I think we have to assume that Israel's arguments before the ICJ that such an order would essentially hamper them and impede their right to self-defense in terms of being able to target Hamas was compelling to the International Court of Justice. But notwithstanding the fact that it didn't issue that measure, an order that the military operations cease, it did order Israel and the Israeli Defense Force should not commit any of the acts that constitute genocide, that it should preserve evidence of any acts that might go to proving or establishing genocide. And I think importantly, in a way that the International Court does not generally do, but I think as a measure of the seriousness of its findings and of it wanting to compel compliance on the part of Israel, it did order that Israel report back within a month of the measures that it would take to ensure that it was meeting the International Court of Justice's order. And yesterday, the deadline passed for that. I understand that Israel has provided such a report. I have not had sight. I don't know what the contents of that report would be. I do want to say just three things then in conclusion. One, and I don't want to get too technical. I know this is not a legal audience, but just to go back to this defining characteristic of genocide, this dolus specialis. In domestic criminal law, we say in order to convict somebody of a murder, they must either have dolus directus, so they must have specially intended to kill that person. They must have dolus indirectus, which is maybe, they wanted to kill the victim and his wife. The intention was really most directly in respect of the deceased partner, but they knew that they would also be killing the partner. And then there is this concept called dolus eventualis, which is that you proceed reckless as to the possibility. And so you might set a house alight, and you might not intend to kill a person directly, but you might be aware that there are people who will be in that house that you're setting alight. And in setting alight and in killing the people, a court will find you guilty of murder on the basis of dolus eventualis, in that even though it wasn't your direct intent that you kill the particular individuals, you nonetheless foresaw the possibility. Here we have a different concept, which is this dolus specialis concept. And this is that you actually engage in the acts. So you engage in killings, you engage or you impose upon the group conditions calculated to bring about psychological trauma, physical harm, with an intent to destroy them, to annihilate them in whole or in part. That intent, in fact, has not been particularly well considered in international law, and has allowed for much debate. And so there is a debate to be had, for instance, as to whether aspects of apartheid, in fact, were genocidal in nature. It's uncontroversial that apartheid is a crime against humanity. Were there aspects of apartheid, for instance, the homeland system, that were genocidal in nature? That is something that I think it could be considered. One of the other things that I wanted to just alert us to is that, South Africa's application, I think, is important, and South Africa deserves enormous credit for having brought this application to the International Court of Justice. And I hope that it will, for those of us concerned for international law and the protections that it holds out, I think it allows us to start thinking about the types of protections that are owed to people who do not have any legitimate authority or any legitimate representation. So again, if I can go back to domestic law, in domestic criminal law, there is this idea that it is better to allow a guilty person to go free than that one innocent person be convicted or punished. That analogy doesn't have any purchase in international law, and particularly the law of armed conflict, where for centuries it's been understood that in fact, innocent civilians can be killed, they can be collateral damage, as long as that is understood to be proportional to the strategic target that is sought. And generally, there hasn't been much there hasn't been much problematization of that concept, because in a context of war, generally the parties engaged in the conflict are seen to be symmetrical. But in a context as with Gaza, right, where because of the historical contextual factors, you do not have a people who can be said to be legitimately represented. The last time any elections were held in Gaza were in 2007, and many would maintain that Gaza, to all intents and purposes, remains under occupation. And I think what we're then required to ask is, are the duties, the obligations that we owe to civilians, to innocents, in a situation of conflict, not that much greater, particularly on the part of the party that is engaging in the conflict, where they do not have any legitimate representative, where there is no proper state authority. And I think that this application should prompt us to think about how we extend our protections to those persons who I think are most vulnerable, in that they do not have any real legitimate authority, a representative authority. And then finally, I would just say, as I said, I think South Africa should be applauded. It deserves credit for this application. I think it has been a sort of tremendous intervention, and hopefully will secure, we can only hope, greater protection for the people of Gaza, certainly help shift the narrative on the public stage. But we have to hope, obviously, too, that this bodes well for South Africa's upholding and continued conviction in the importance of international criminal law, its commitment to the International Criminal Court, and to its obligations thereunder. And I'll leave it there.
Thank you, Nicole. Very powerful conclusion. Thank you for that. Ottilia, I'm handing right over to you. And welcome.
Thank you very much. And as with everyone, a special thank you, of course, to the University of Johannesburg for convening a very important series, because most of these conversations are had in corridors or coffee shops, and not so much in a platform like this, where we can exchange on these issues. What I'm going to do is really build on what both Zahir and Nicole have done, connecting, if I can, the political, legal, as well as other measures through which South Africa has been involved in the Israel-Palestine conflict. And so there will be some elements here and there that sound like repetition, but please bear with me. And I will try to do this in under 15 minutes so that there's more time for discussion. So first, in terms of laying the scene, I suppose, is to say that there are many tools that are available in South Africa's toolbox to be able to engage in any context. And these are some of the tools that South Africa has used specifically in the Israeli-Palestine context. And these include through diplomacy, but they also include using the institutions, international institutions made available to do that. At the UN, this has meant the UN General Assembly, the UN Security Council in part, also the UN Human Rights Commission and Council, and then, of course, on the judicial side, the International Court of Justice, the International Criminal Court. I start by stating all of these institutions because, of course, Sometimes we speak about the one as if it exists in isolation of the others, and as if these processes are not meant to both supplement but also complement each other. This is perhaps one of the contexts in which South Africa has dug out all these tools within its toolbox. So Zahir spoke, of course, to the historic relationship between South Africa, but also with the Palestinian cause and with Israel. And he spoke, of course, to the often tensions that exist. Nicole spoke to the role of the International Court of Justice and the use of the instruments available at International Court of Justice level, speaking specifically about the genocide case. When I wrap up at the end, I'm also going to focus on another International Court of Justice process, which is the request for an advisory opinion on the occupation of the Palestinian territories by Israel. And in so doing, kind of paint the picture of the many different options that are there to engage and the ones that South Africa has chosen. Why South Africa has chosen to involve itself in this case, Prof. Van Niekerk did a really good job in introducing this because, of course, of the history pre-1994, in which, of course, the Israeli state supported apartheid, or the apartheid state in South Africa, and then post-1994, where we saw greater solidarity with the Palestinian cause. So this is by no measure a new thing. Also within the space of history, I'll recall at the end of December, when the application by South Africa in respect of provisional measures came through, there were a lot of questions around why is South Africa doing this, but also importantly, where has it been? And so I had to dial back a bit, even in my own history, to remember, of course, that people like the former Foreign Minister of Israel, Tzipi Livni, were unable to travel to South Africa in 2011 because there had been a pending application at the High Court here in Pretoria for her arrest for her role in Operation Costlead between 2008 and 2009. I also recalled that in 2014, when there were pushes to refer the situation in Palestine to the International Criminal Court, that South Africa was very much behind that push. And even when it came to the UN General Assembly voting on the statehood of Palestine, that South Africa was among those countries that supported the recognition of Palestine's statehood. These are all events that happened before 2023. So to situate the relationship earlier helps others to understand why South Africa is invested in this process, and why that investment goes beyond just the international criminal justice or justice mechanisms, but also towards voting patterns at the UN General Assembly. What matters, though, is beyond looking at the history, and as we focus now in unpacking South Africa's role and its relationship with both Israel and Palestine within the context of the conflict, I'll say one thing, semi-controversial, but not fully, I hope, which is that South Africa has played many roles. The one role that it would not be able to play within the context of Israel and Palestine is one of mediator. South Africa would not be able to play that role because it's made it very clear on which side it stands. And by making that clear, it means it's unlikely that even if there were to be another mediation process beyond the ones that are underway, that Israel would not agree to a mediation in which South Africa is the mediator. That doesn't mean that it can't be part of the process in negotiating and working together with the Palestinian authorities and exchanging with the Israeli authorities, but it does mean that the impartiality that is required to mediate is not there. I'm now going to turn to the two current ICJ cases. I'm not going to go into much more detail than Nicole did on the South Africa versus Israel matter, but to reiterate a number of points. The first point is, of course, that this is an invocation of the Genocide Convention, to which both South Africa and Israel are party, and that it goes beyond just about preventing or punishing genocide, but also includes the importance of the preservation of evidence as well as humanitarian aid. Over the weekend, Human Rights Watch released a report in which, before Israel released its report or submitted its report to the ICJ, in which it pointed out that specifically on 2 points that were raised at the ICJ application for provisional measures, that in their mind, Israel had failed to comply with those orders. These two were to allow humanitarian aid to access the occupied Palestinian territories, particularly in Gaza. The second was on incitement to commit genocide. For Human Rights Watch, they argued that because in the past month, there have been incidences where senior government officials have made statements that could be read to incite more violence and have done nothing to curtail that. And then also that we've seen humanitarian aid convoys either being stopped, blocked, or attacked, that this amounts to non-compliance. As Nicole pointed out, the report by Israel to the ICJ has not yet been made public. And of course, the South African authorities will have an opportunity to go over that report. And the reason South Africa must go over the report is if in South Africa's mind there is non-compliance, it may still be able to apply to the ICJ essentially for a form of enforcement. In past cases where such provisional measures have been ordered, such as in Myanmar versus the Gambia, the reporting requirements were essentially every 2-3 months in which the government of Myanmar had to report, whereas this provisional order that was given by the ICJ in January was a little bit more circumspect. And I assume it is so that South Africa can be able to assess the compliance, but also the judges to assess the compliance. If it is that they find that there has been no compliance or limited compliance, then an extension of the reporting requirement will likely stand. I think what's important to emphasize here is that all the other provisional measures were not put in place with an end date of the 26th of February. Those still apply, and it is against the implementation of those provisional measures that there may even be the room for criminal prosecutions. I want to stress here that a criminal prosecution does not mean only Israelis will be prosecuted. If it is that in the course of the investigation, and this would be either by the International Criminal Court or any domestic court that has universal jurisdiction, that indictees can also include people from Palestine, including those that are serving under Hamas. So that is to re-stress that the provisional order remains. Israel has submitted its report. It's not yet been made public. The extent to which it has been able to implement that provisional order is something that South Africa can be able to assess as a party in the case, together with the judges, but also that opens the door for the possibility for an enforcement mechanism, such as through the UN Security Council. But we know that the UN Security Council has been unable to pass a resolution on a ceasefire. Just last week, the US vetoed a resolution on a ceasefire. 13 countries voted for it, and the United Kingdom abstained. And this was, as I segue then to the other ICJ process, this was a day before the United States argued at the ICJ in the matter for a request for an advisory opinion on the occupation. So this is case 2 that the ICJ is dealing with. So while they're dealing with the genocide case that South Africa has brought, they have been asked also by the UN General Assembly to deal with the question on the occupation of Palestine or Palestinian territories by Israel. Most of the arguments, and they ended yesterday in the public hearings, focused on the Fourth Geneva Convention, specifically around transferring of civilian population, either Israeli civilian population to the occupied territories, or deporting or transferring any of the Palestinians out of the occupied territory. But they also focused on I will focus on two additional ones. There were many. They also focused on two other aspects. The one which was brought on board by South Africa, but more strongly, I would say, by France, related to the characterization of the occupation as colonialism. So that in effect, the continued occupation is and can be read to be a colonization. The second, which was invoked by South Africa, but also echoed by a number of countries, including Ireland, including Spain, were that what the policies that Israel is implementing in the occupied territories amount to a violation of the Convention Against Apartheid. So three main pillars there: the crime of apartheid, the allegation of colonialism, and then the legality of the occupation. So this is something now that the ICJ has to deal with. I will say it was quite symbolic, at least from a South African point of view, that the first country to present their oral arguments at the ICJ after Palestine was South Africa. And that some of the arguments that were raised by South Africa, particularly in respect of apartheid, were then carried forward by a number of other countries. The majority of African countries that presented at the ICJ last week and on Monday, just yesterday, re-emphasized a number of those points. What does that mean really in real terms, though? It does mean that we're seeing a coalescing of views and opinions around particular causes. It also means that the instruments that are available for any country, and South Africa has used as many of these as it can, are being used. Perhaps it is a reinforcement that, as weak as we may perceive the global system to be, that these tools do exist and they can be used, be it the UN General Assembly, the UN Security Council, the Human Rights Council, the International Court of Justice, or the International Criminal Court. But they're also testing the ability of these institutions. I opined a couple of weeks ago when the ICJ handed down one of its orders in respect of the case between Ukraine and Russia, with 32 other countries that were intervening, that this is the busiest the ICJ has ever been. And it's not to say that the ICJ is not a busy court, but for statements coming out of the ICJ on a weekly basis, this is indeed the busiest that the court has been. So, and I end on a number of points, Antony, here, which is to say that South Africa is using the instruments available at international stage. It's also supporting calls for activism in solidarity with the Palestinian people. And instead of, I suppose, opting, if I can, for an aggressive posture, it's offered instead to rely on the institutions and instruments that are available to be able to deal with the varying issues around Israel and Palestine, not only on genocide, also on occupation and on the crime of apartheid. Thank you very much, Antony.
Thanks, Otelia, for an excellent presentation, very clear. Before I give the floor to John, I just want to remind our panelists to keep one of your eyes on the chat box and the Q&A. Issues are emerging there. Some specifically for panelists, but also there's a conversation going. just see if you can follow that as well. When it's Q&A time, I will summarize what it is that is emerging from the audience. John, it's over to you.
Thank you, Anthony, and all protocols observed. Everyone has been very complimentary to the University of Johannesburg, and we have a daughter who's on the faculty there, so I'm very pleased to hear that. But I'm going to try to keep my remarks to 15 minutes and begin by saying, which everyone has already, that the preliminary findings of the International Court of Justice in favor of South Africa's claim that it was plausible that Israel was acting in ways that violated the Genocide Convention has been praised the world over, including by me. Almost all restraints South Africa called for on Israel's conduct in Gaza were approved by the court, except for the demand for an immediate ceasefire, as you've heard. While that was and remains the #1 priority for addressing the humanitarian catastrophe, I believe a call for an immediate ceasefire would have split the otherwise nearly unanimous rulings in South Africa's favor by the court, including the Russian and the Americans, plus Israel, like Russia, would have ignored the court's ruling, as Russia did after the invasion of Ukraine was condemned by the court. So relying on a U.S. veto, that the Israelis would have also denied the court's ruling, and things would move on. In any event, the ideals of universal human rights have to gain enforcement powers, obviously, in a world still dominated by sovereign states. So I believe that it was the next stage and is best left to diplomats trying to get at least a temporary ceasefire, release of the hostages, and creation and support for an independent state of Palestine, which the Israelis have opposed. It begs the question in the short term of South Africa's involvement, but I think Otilia was signaling there may be opportunities down the road. The Hamas is not a party to the Genocide Convention, but its agreement to any ceasefire deal is necessary, and the long war with Israeli settlers from Europe goes back to 1948, as we've heard, and bitterness is primordial and runs very deep, however man-made the sectarian identities in play in the Middle East are. This is where the realities of international politics and morality are complicated and unpredictable, including possible further intervention by South Africa. Reports yesterday suggest that Joe Biden is now upbeat about progress getting a temporary ceasefire, release of the hostages, and more humanitarian relief. Then a couple of hours ago, the New York Times reported a Hamas leader dismissed Biden's claims. Talks in Doha, brokered by the US, Qatar, and Egypt, may well be making progress, and Biden predicted an announcement by Monday in plenty of time for the IFK to assess prior to the second session of this webinar on March 12th. But let's see if anything happens on Monday. I am still cautiously pessimistic about the political sustainability of a deal, and I give 6 reasons why I am pessimistic. 1, first, neither side has leaders who appear prepared to negotiate core issues, take risks, and take ownership. In short, it is a zero-sum, not a win-win situation. Hamas leader Yahya Sinwar is no Nelson Mandela, and Benjamin Netanyahu is not F.W. de Klerk. Secondly, moreover, Netanyahu presides over the most extreme right-wing government in Israel's history. Netanyahu has opposed a two-state solution for 30 years. And while credible polls of Israelis show he is very unpopular, I've seen rankings of 15% or less, most Israelis, 63%, oppose the creation of a Palestinian state, even with the added incentive of normalized relations with Sunni Arabs, such as Saudi Arabia and other Sunni Arab states. Now, Biden could talk directly to the Israeli people and maybe make a case for a two-state solution, but that's debatable. Third, risks are of an escalating regional conflict involving Iran, Hezbollah, Houthis, and others are ever present, although recent reports suggest both Iran and the U.S. seek to avoid a direct confrontation and are trying to de-escalate, but I'm just following the same reports you are. Fourth, the U.S. veto of UN Security Council resolution last week calling for an immediate ceasefire, even Ukraine abstained, as we heard from Otilia, has discredited the U.S. with the global South and many G20 foreign ministers. An open mic revealed not just Brazil and South Africa criticism at the G20 foreign ministers, but Australia and other U.S. allies were also critical. Fifth, Russia, China, and other authoritarian regimes, Iran and Saudis have their Shia-Sunni issues, will seek political advantage from the Gaza war to discredit democracies, despite South Africa's efforts to set higher standards, which are good efforts. That ANC party secretary, Fikeli Mabalula, was in Moscow when Alexei Navalny was killed, but he and South Africa failed to condemn. Doesn't help, in my view. Sixth, and finally, states often pursue double standards, the bane of any analysis. The U.S. supports self-determination in Ukraine, but less so in Palestine. South Africa supports Palestinian self-determination, but less so for the Ukrainians. While the U.S. has a higher interest in South Africa than South Africa does with Russia, it still remains to be seen what is driving these interstate relations, and that it interests Trump too often, and pun intended, values that we all hold dear and we have heard a number of people talking to in the course of this webinar. All this risks cynicism about the prospects for the advancement of universal values. South Africa's recent approach to the World Court is rightly praised as a much-needed counterpart, but the hard work of diplomacy has just begun. This leads to my last issue. One I am grappling with in a comparative study of Americans and South Africans, thanks to Frederick Douglass, by the way. It is the dilemma of all struggling democracies, those struggling to transition from predominantly sectarian, ethnic, tribal, racial, religious, including the United States of America right now, hence the Trump reference. How to reconcile commitments to universal values may conflict with the imperatives to pursue state interests. Often those who denigrate or defy the universal principles that South Africa invoked in engaging the World Court, temptations to defy universal values, notably human rights, often prevails in a world of sovereign states and power politics. National identity defined by loyalty to the Constitution and the Bill of Rights is a lot weaker than appealing for national loyalty to ethnicity or religious identities or other racial identities. Aspiring liberal democracies with extreme inequality, mass poverty, and unemployment are especially hard-pressed to inspire their citizen national loyalty, especially with load shedding and other basic failures that we're experiencing here in South Africa. South Africa's commitment to universal human rights, so eloquently and convincingly on display by our team of world-class lawyers last month in The Hague, give me hope. But the transactional motivations yet to be revealed, but obviously driving relations between Russia and South Africa, and I would argue the rest of the BRICS, may well be deemed to be in the vital interests of this republic. And who's to challenge that? There may be yet a breakthrough in the Middle East diplomacy where South Africa can again shine as an advocate of universal values, of basic human rights, but I am skeptical. Steve Friedman in the February 8 article of Foreign Affairs entitled, quote, South Africa's quest to retake the moral high ground about South Africa's ICJ case, he argued, quote, reflects a change in the way the country's government sees itself and its role in the world, a return to its identity, a decision to finally incorporate the best, most distinctive elements of South Africa's post-apartheid culture into its approach to the rest of the world, unquote. While I want to agree the Hamas attack of October 7 was horrific, but needs historic context of Israeli settlers attempting to rid the land of, quote, natives, as Mahmoud Mamdani documents so well. When I first visited Israel and Palestine in the 1980s, Israeli Democrats were calling for an end of apartheid-like conditions in the Palestinian territories. And this is now 2024. South African success thus far in gaining world court endorsement of their claims that violations of genocide convention and that South Africa and Israel signed in 1948 are at least plausible, accelerated and popular and diplomatic pressures on behalf of the Palestinians globally. But it's ironic that the only African who signed the Universal Declaration of Human Rights was South Africa, and South Africa and a couple of others, but that Jan Smuts is credited with having contributed to the declaration some language. That was the only African who contributed to the language of the Universal Declaration. It is a supreme irony. But universal values lack collective enforcement in a world still dominated by sovereignty and transactional nation-state interests. This won't and cannot gain a ceasefire and immediate help for those vulnerable and desperate in Rafah. For that, we need a ceasefire, relief, and hostages released. And the basis for a viable, rebuilt, and decent Palestinian state. Should talks proceed, there may even be a role for monitors, and it's worth recalling the critical role that Cyril Ramaphosa and Mati Ahazari played in getting the Good Friday Peace Accord in Northern Ireland adopted and sustained. South Africa is trusted by the Palestinians as well as Ramaphosa was by the IRA, which can be an essential for advancing peace. Thank you.
Thanks, John. Thoughtful and provocative at the same time.
And on time.
And you're on time. Good for you.
No, we're all on time.
I want to. No, you talk a lot. I want to. I want to make this arrangement. We've got a bit of time before we have to close, about 30 minutes. I want 2 rounds. The first one, there's a very lively conversation going on in the chat box and in the Q&A. I'll bring them to you in summarized format. And in the second round, I'm going to ask you again to help us to understand a bit of the future. Give us hope. Tell us what might be possible. What needs to happen next? What is the way forward? But let me start quickly with the kind of questions that I see has now emerged. Zahir can I start with you? Many people ask, not only now, but in general, when we think of government's position and Dirko's position, seemingly double standards on display by government. There's the approach to Ukraine, but then there's the approach to Israel. And what about genocidal behavior and conflicts in Africa, the DRC, Sudan, Somalia, elsewhere? That's the first question that I'm bringing to you. Give us your perspective. The second one, Zahir, an emerging theme is the inability of the UN system to really govern on our behalf as citizens, as humanity, and in particular, the question of the Security Council that seems to be unable to maintain or restore international peace and justice. What are the prospects for a Security Council reform, for UN Security Council reform? I heard, of all people, Antony Blinken speaking at the end of the G20, or was it G21 Foreign Ministers Summit a few days ago, speaking on behalf of the collective, saying that America is in favor of Security Council reform. I wish I could ask him what he meant. Nicole, I know that you are still with us. People are scratching their heads. They want to understand how it is that South Africa arrived at the International Court of Justice with a team of very able lawyers putting together a coherent and very persuasive argument. Who are they? How were they assembled? Who told them what the mandate was? How did that work? How did we arrive at a position? And the second question, it's also an emerging theme, Nicole, is international law toothless? So we get courts who make pronouncements. We ask parties to come back and report on progress or not. And some parties and some political leaders say, I don't care what the court or the law says. I've got another project. Ottilia, you were provocative in your excellent overview by saying that South Africa cannot possibly be a mediator. It has chosen a side. But in the Israel-Palestine conflict, who has not chosen sides? Who can be seen as a neutral mediator? Not even the UN is viewed by the Netanyahu government as credible. In fact, they want the Secretary General to resign. So what makes a party attractive as a mediator? And I remember, as Africans, we have experience of mediation. And in fact, that's the topic for another seminar, I think, UJ. Our mediation experience in Southern Africa and further afield. I mean, the most pressing thing now is whether we make war in the DRC or we bring peace. So what is it that makes mediation possible? What are the attributes of such a party? John, people want to know what the impact of this South African position on Gaza is, or on the Israel-Palestine conflict, on South Africa's relations with the US. There's a lot of media noise. I don't know if it's white noise or unnecessary noise, or part of an information or a disinformation campaign, saying the Americans are about to punish the South Africans for taking such a very powerful position. What is your view of and you've spoken about this before, but give us a short version of your view of South Africa-US relations. I think it's critically important to also understand that dimension. And I also want to ask you the very same question, do you see any prospect for a meaningful reform of the Security Council of the United Nations? This is the first round of questions. I'm going to hand back to you in the speaking order that we started, because I want us to conclude with the way forward. And then you're sort of bringing together some of these themes. Zahir, it's over to you.
Thank you very much, Antonio, and thank you for the very lively comments and the interest that is being shown with regard to South Africa's approach. Look, I think I'll touch on the issues that have been raised in terms of how you've summarized it. Firstly, with regard to South Africa's approach on Ukraine, we have said from the outset in February 2024 February 2022, when Russia went into Ukraine and violated its territorial integrity, which South Africa has said is a violation of the UN Charter. We have maintained a consistent approach that ultimately the issue of Ukraine can only be resolved through a ceasefire and through negotiations. This is the identical and the same approach we have taken with regard to Palestine. We have said we want a ceasefire and we want negotiations. We have consistently played a role throughout this Ukraine war in terms of supporting processes leading towards peace. South Africa, as you are aware, President Ramaphosa has been part of a process with other African leaders engaged in the Ukraine peace process through the African Peace Initiative. Additionally, South Africa is part of the Ukraine Peace Formula. We participate actively in meetings of the Ukraine Peace Formula to assist in moving the process towards peace. So we don't see any contradiction in us trying to ensure that there is an end to conflict and that the parties comply with international law. That has been a consistent approach. With regard to other conflicts and whether there's genocide, look, the issue of genocide is a very difficult issue in terms of the convention. I think Nicole outlined it, Ottilia touched on it as well. Genocidal intent is a very, very difficult issue to prove. From our perspective, in the manner in which our legal team approached the ICJ matter, without going into that particular issue, because that is a legal process, we believe that there was ample, and as indicated by our legal team, there was ample evidence of genocidal intent in this particular case. Whether that can be proved in other cases, that is very difficult. That is another matter. There may be other violations of international law in other conflict areas, but in this particular matter, we believe there was ample evidence of genocidal intent. With regard to the issue of reform of the Security Council, first, I want to underline and emphasize what Ottilia mentioned. The fact that despite the fact that we may believe that multilateralism is under threat, collective action is under threat because of the geopolitical tensions that exist, and that is a reality. We're seeing that in the negotiations that are taking place over various multilateral bodies. But the positive aspect of this is the fact that countries are resorting to multilateral mechanisms to advance specific objectives. The number of countries that appeared before the ICJ last week and the week before on the current matter of the ICJ, the GA referral, is an indication that despite the weaknesses that may exist, the ICJ is a UN principal organ in terms of the UN Charter. Countries believe, obviously, by appearing before the court and wanting to have their cases heard or their views heard before the court, there is a confidence. We would believe there is a confidence and support for the international multilateral mechanisms at our disposal. The General Assembly has been reactivated in terms of the matters that are appearing before the GA, where there is a belief that the General Assembly, which represents ultimately the voice of every single member state, is a legitimate mechanism to bring issues to the fore. Of course, the Security Council does suffer from a serious credibility deficit. It has not been able to resolve a number of key issues on its agenda, and largely because of the use of the veto by the permanent members when issues related to their own national interests or that of countries where they have strategic alliances with are affected. We've not been able to get decision making. We have not seen, of course, we can go into a long debate and discussion on why the Security Council has been ineffective. But why it has not been effective in Syria, for example, perhaps also because of what has happened in the past with Libya and in Iraq, etc. Why has the Security Council not been able to make any meaningful impact on Ukraine because of the veto of one of the permanent members, because it is directly affected? Why has it not done anything meaningful on Palestine, despite the fact that there are numerous resolutions, including Security Council resolutions on the matter, for example, on settlements? So reform is crucial. We of course are engaged in a discussion in the General Assembly to work towards reform of the Security Council and the UN as a whole. But ultimately, because of the structure of the UN Charter, and many of you are aware of this, it is a very difficult discussion. In September this year, the Secretary General will be convening the Summit of the Future, and we are negotiating as member states a pact of the future, which we hope will be an attempt for us to again galvanize political support for improving the UN, making it more credible, making it more fit for purpose in terms of dealing with the issues of the 21st century and not the issues of 1945. This is an opportunity for us to show that political commitment. You indicated the US Secretary of State's commitment to reform, or his President Biden, for example, said something similar at the General Assembly 2 Septembers ago at the opening of the General Assembly. How this now translates from all member states towards making meaningful reform will be something we would need to see. Finally, and I'm sorry to take up so much of time, I wanted to touch on the issue of mediation. I know that it wasn't really my issue, but I wanted to bring this in terms of who will play this mediating role. For us, as South Africa, we have consistently said it's for the UN to play this important role, because we believe the UN remains at the center. The UN, rather than what you've seen in the past, where the US or the Quartet have tried to play this role. The Quartet, I think, from our perspective, was not very successful, because what you saw was parties trying to leverage their political positioning rather than playing a role. But ultimately, what led to Oslo? And we can debate whether the pros and cons of Oslo, but you had a Madrid peace conference that led to Oslo. You had a conference of interested parties. And I think one of the things that we often overlook, partly because of when it took place in the dying days of the Bush administration, but the US convening the Annapolis meeting was a very useful manner of trying to galvanize support for a peace process. You would recall, towards the end of the Bush presidency, there was this attempt to try and get this international conference in Annapolis to get all countries that were interested in peace, including South Africa. We were invited as well. Despite what we may, and I also want to reiterate what Atulia said, nobody would be surprised by what we did with the ICJ. It's a consistent position since 1994 in the manner in which we've approached the issue of Israel-Palestine. Yet we were invited to Annapolis. So I think there is a role for all countries that are interested in finding a resolution to peace. And this should be done under the auspices of the UN from our perspective. Let me end there. Thank you.
Yeah. No, thanks, Zahir. I want to challenge you when you go back to your principles to say that as academics, we want Dirko to lead a workshop in this style on this UN summit of the future that is coming up in September. We want to input in the South African position, the African position, the BRICS position. It's a critically important moment, I think, for global governance. So we are reaching out to your department. Put that in your report to the DG. Shall we move on to Nicole? There were some questions for you, Nicole.
Yes, thank you.
Thank you.
So just to explain how South Africa arrived at the International Court of Justice with its application, and to underline again, for those who are not lawyers here, international law has a different basis from domestic law. International law is founded on the basis of consent, and so states essentially surrender a part of their sovereignty in order to be bound by the dictates of international law, but they must have done so voluntarily. And so South Africa is not at liberty simply to take any state to the International Court of Justice on the basis of, any infraction. If a state is going to proceed under the International Court of Justice against another state, it needs to have a operating vehicle by which the two states have given their consent. So here it was the Convention Against Genocide. South Africa and Israel are both parties to that convention, and South Africa maintained that it had an obligation in terms of that convention to uphold the provisions of the Genocide Convention, and it maintained that Israel was violating its obligations under that convention. Atilia has referenced this. The other case that is proceeding before the International Court of Justice at the moment, and that is a request for an advisory opinion. Technically, it's not a case against another state. It is requiring the International Court of Justice to issue a determination on a legal question. Obviously, Israel is implicated in this question that is in respect of which clarification is sought. But this is not a case against another state. It is one in which a legal opinion is sought from the International Court of Justice, whereas South Africa brought its matter against Israel in terms of the convention, the Genocide Convention, on the basis that the two states, the two antagonists in this case, had essentially offered their consent to be parties before the International Court of Justice by having become members of the Genocide Convention. And then I should just say, I mean, I do think, and again, you know, I will say this again, I think DIRCO deserves credit. I think that there was a recognition, an energy, an innovation on the part of the department to use the mechanisms available and to seek to access the International Court of Justice. And so I think we've got a number of personalities there who were very sort of key to this initiative. You know, the person who led the South African council team there was Professor John Dugard. John Dugard is seen, you know, very much as kind of a father of international law in South Africa. He wrote many of the kind of key treatises on the extent to which South Africa was violating international law in its perpetration of apartheid. And he has been appointed a UN special rapporteur and earned the ire of Israel for having come to the conclusion that Israel was committing the act of apartheid in its occupation of the occupied territories. And I think he was also very much a kind of formative part of this initiative. And then we had, you know, any number of really tremendous council in South Africa participate. And I think they did a very convincing job, not only in enumerating the acts that were genocidal, but also in addressing the intention requirements, the extent to which various statements on the part of high-level Israeli authorities indicated that the intent requirement could be satisfied in respect of proving genocide. So that would be my answer to that first question. And then the second question, is international law toothless? I mean, I certainly would say that we would want international law to be much more kind of rigorous and demanding of observance than it is. To some extent, the deficiencies are baked in because it is this system that requires the consent of the parties themselves. I would say, though, that if it were so meaningless, Israel would not have sought to defend itself in the way in which it did so vigorously before the International Court of Justice, and neither would it have taken on, and other parties like the United States sought to denigrate South Africa in the way that we did ahead of the hearings. Were they to feel that international law was so meaningless? It's not meaningless. We can absolutely wish that it had much greater effect, but I would say that it isn't meaningless. I would also say that one of the things that we need to be mindful of is that in making this application, South Africa sought to uphold the multilateral system and its organs. As a mid-power state, it has a vested interest, whilst, and we've discussed this in this presentation, we know that South Africa's interest certainly lies in seeing reforms of the institutions of the multilateral system, most obviously the Security Council. South Africa doesn't want to see an abandonment of this system, and unfortunately we inhabit a time in history when there are too many actors who seem only too keen to tear down and to abandon our multilateral system. And I think, again, one of the lenses that we should view this approach to the International Court of Justice as being as an attempt to reinforce and uphold the multilateral system and what it can do, rather than this kind of knee-jerk response of the fact that it's toothless, it's pointless, we should all just abandon the system.
I think you rose to the challenge quite well, Nicole. Thank you very much. Otelia?
Thank you very much. There was one that you directed straight at me, Anthony, that I'll respond to. And then I'll also maybe just respond to the question that Jared Moodley put in the chat around what constitutes apartheid. So
I saw that,
yeah, just to clarify, right? And I think my statement aligns very much with what Zahir also provided. It is not to say that South Africa cannot be part of a broader process. It is to say, in order for you to mediate not only in the situation, let's say Palestine or Israel, even if in whatever distant future South Africa were to be called on in any format to engage on the question of Western Sahara and Morocco, because South Africa's position within that context makes it such that both parties do not perceive an equal footing in how they engage with the mediator, that a mediator needs to be trusted. It's not to say that South Africa is not trustworthy. Let me phrase this in a way that is clear. It is to say that the parties to the conflict must trust the mediator. Now, if in the case of Palestine and Israel is of the view, and it has articulated that view publicly already, not only in respect of the ICJ matter, but when in November last year, President Cyril Ramaphosa, following the BRICS session, stated that in the view, at least of the executive, that genocide was being committed in Palestine. That was the first really post that where you saw Israeli government officials at different levels, from communications to the Prime Minister's office, basically suggesting an over-politicization. What that means for South Africa is, while it can be part of the process, it would not be brought in as the mediator. And you can replace South Africa, you can replace Palestine, Israel, in other contexts to determine what countries would not be best placed to mediate. In some instances, a mediator does not have to be a state-based mediator, right? So in some instances, you find that an independent individual, unaffiliated with the state that they're from, but who has served in that function before, usually that is done through the vehicle of the UN, that person then works independently in that mediation process. So there are many different ways that a mediation process can be established, but to say the individual or the individuals that are identified as the mediator need to be seen by both parties as sufficiently objective and sufficiently impartial. And I feel in this situation, South Africa is not perceived as impartial in respect of where it stands on Palestine and Israel. Then on the question on what constitutes apartheid. Now, a lot of people don't know this, but the International Convention on the Suppression and Punishment of the Crime of Apartheid is 41 years this year. No, 51. Sorry, I'm doing my maths all wrong. 51 years, right? And within the additional protocols to the Geneva Conventions, apartheid is also included. And the full definition there includes, and that's why I liked the statement that Nicole made, because we've never really framed apartheid as possibly constituting genocide. But the extent to which, in implementing those policies, which may include murder, which may include inflicting certain conditions on a group related to their life and liberty, which may force racial groups a forcible segregation and separation, that depending on the intention behind imposing those apartheid measures, it can reach the level of genocide. Now, what I want to also stress here in our end is I am a lawyer perhaps to a fault. And because I'm a lawyer perhaps to a fault, sometimes we don't have to reach the high threshold, right? So people argue for days on end as to whether genocide is being committed, but no one disputes that 30,000 people have been killed. Now, there are many different ways that you can hold people accountable for those deaths, including genocide, but you can also look into direct criminal responsibility for each individual death. And I think my message here is to say there is a bigger picture, let me put it that way, around a system of oppression, around the methods used. But if we only focus on the bigger picture, so to speak, we can lose the forest for the trees. We can actually then have no one held to account. And that is why I mentioned in the toolbox, I mentioned the ICJ process, the International Criminal Court. I also mentioned domestic processes. There's nothing that prevents that happening. And we have seen individual countries issue arrest warrant or attempt to do so in respect of perpetrators, not only in this context, but in others as well. And I reference Operation Cost Lead, which is now 16 years old, but there have been some arrest warrants issued in countries like Switzerland to former government officials for their role and complicity in the use of white phosphorus in a time of conflict.
Before you go, Tulia, thank you very much. Do you have a view on whether Israel views South Africa as a not as a credible mediator, or is it the case that the Netanyahu coalition government has expressed its displeasure at South Africa's intervention? So behind Netanyahu and his coalition, does there sit a group of Israelis who might be able to say, if there's a domestic change, perhaps, that it can open the door for the process to take off again, where South Africa doesn't lead the mediation, but becomes part of the process that all of us are discussing now? Do you have a view on that?
Yeah, easy answer, Anthony, because of course the current political leadership is then what informs who is invited and who is involved in a process, right? That is not to say under a different administration that South Africa cannot be perceived as sufficiently impartial and objective enough to be part of a process. So it's not an absolute that South Africa can never be part of the process. It is recognizing that today, 27 February 2024, the current administration won't stretch their hands to involve South Africa. But if things change, and I want to maybe just add something here. 2 years ago, almost to the day, and then also last year, the former Prime Minister of Israel was at the Munich Security Conference and spoke about, which I found fascinating as an outsider, but he spoke about his particular views on the extremism of the current administration, which I found quite interesting because when he was Prime Minister, this is Ehud Olmert, when he was Prime Minister, he was regarded as quite extreme. And then you have him coming forward and saying there won't be much in terms of negotiation under this administration because it's a weak coalition of multiple actors who are currently united on one point and one point only. And I think it's worth reminding people that before October 2023, there were protests on the streets of Israel against the current government, including against their measures to try to curtail the scope of the powers of the Supreme Court and on questions of accountability. So it's not unheard of that things could change, but currently unlikely, I don't think.
Thank you, Otelia. I'm going to ask John to come in now, unmute and show your video. And you'll be the last one to speak to the questions.
Well, Anthony, the easy way for me to cop out is to say, talk to me after May 29 and talk to me after November 5th about
No,
U.S.
you don't have the luxury of that. We're going to push you now.
and South Africa. Well, but all politics is local, and particularly in democracies. And the Otilia was just mentioning Israeli democracies, which is very limited and very ethnic centric and a settler democracy. But nevertheless, there are differences of views. And in 1985, because I know that Nicole mentioned John Dugard, Marin Ben-Venisti, who was the deputy mayor of Jerusalem, told me he would not participate. He was doing a joint project with Dugard, and he would not come to South Africa because he didn't want to see apartheid on a grand scale. And with regard to the South African service to the Americans, by avoiding a race war here, given the tensions in the racial community back home in the States, the South Africans did an enormous favor. And indeed, Mandela probably legitimated Americans thinking about Obama as president, but I'm exaggerating here and it's counterfactual. So that, you know, we are in a very dynamic political circumstance. Now, on the reform of the United Nations, I always said, not in my lifetime, and I'm an old guy, but there, if Biden was reelected, I think Blinken is realizing, and I saw this, you know, South Africans by the ICJ case taught Biden and gave Biden some space and gave Biden some leverage. He hasn't used it very well. And the veto in the Security Council last week may have been hostage to technical questions about the negotiations and where they are right now, because we are in a world of states, and I wish it were otherwise. But I had 51 members of the United Nations when I was a boy, and now there are 193, and most of them are not nations but states only. So, you know, we're in a very creative period where South Africa and Americans, I think, see the world in similar ways. But the question of mediation reminds me also of an invitation that George Bush I wanted to make for sending Baker over, and both de Klerk and Mandela called Bush and told him, no, thank you. If this is going to work, we got to own it ourselves. And I don't see anybody in the Israeli mix and the Palestinian mix right now. So a two-state solution, which we all thought was dead, may yet see the light of day, and South Africa could play a very real role in affecting that. But that's, again, speculation, and I should yield to the way I opened by saying, talk to me after we find out whether it's Malema and Mashatile in a coalition and whether it's Trump, because Trump could care less about the United Nations. He wants out.
John. Okay, I'm. Thank you. People will take you on afterwards.
Good.
Let me say, in the few minutes remaining, I want the panelists to put on their videos so we can see the panel in all its glory. And then I'm going to ask you each one, just give me one sentence on the way forward. We're going to start with Zahir. We've had this conversation. It will continue. There's a part 2. So if you come back to this forum, I can't remember the date now, but the second round will help us to continue with the conversation. But for now, South Africa's role in assisting a breakthrough in this conflict between Israel and Palestine. What is the way forward? What can we expect? Zahir, literally one sentence or two.
I don't think a diplomat could answer in one sentence, but
I know, I'm pushing you hard.
But ultimately, I think, as I said, the positive side of this is the fact that countries are resorting to multilateral institutions. South Africa resorting to an international convention is a positive sign. Countries resorting to the ICJ is a positive sign. Let us go back to the UN Charter and international law, and that can be the rules-based system that we should be grounded on.
Good. That's a good point. Nicole.
I would reiterate that. I would say that to the extent that we look to strengthen our engagement with the multilateral system, understanding that there are reforms that are necessary, I think that that is the way forward. But I would say it's not just about reforming the institutions. I think the way in which conflicts are progressing, the development of weapons that we have not seen the likes of before, the extent of the harm that they cause, requires to rethink some of our laws of war. As I tried to highlight in my presentation, kind of the asymmetries involved in combatants and the particular duties of care that we have to civilian populations who may have no other legitimate representatives.
Thanks, Nicole. Ottilia.
Thank you. Mine is just an added footnote, I think, to re-emphasize the point that Zahir made. There are international institutions that exist that are available for a country like South Africa to use. What I would maybe just add onto that is being able to leverage your history and your present to be able to make those points. As I was listening to the ICJ hearings, hearing countries like Ireland, like Spain, speak to the crime of apartheid is something that I wouldn't have expected, because it's often reduced to a crime that can only be committed in South Africa. And it was important for that messaging to come not only from South Africa, but also from other countries.
Thank you, Ottilia. John, you've heard the others. One sentence.
I would just hope that we get the humanitarian crisis in Gaza solved, Anthony. Or at least mitigated. It would solve so many other problems.
Yes, thank you very much. Zahir, I just want to say before I hand back to the organizers, that this idea of us, participating in a process to help the UN rethink, the future in September, that summit is really, really important. And I think, as South Africans, we need to pull together to get a voice and participate with you guys in there. Thank you very much for all of your comment, analysis, responses. There's more in the chat box. It's the beginning of the conversation. There's a second round, which makes me quite excited as well. I want to hand back to Dr. Teller and thank him for organizing all of this. Thank you very much.
Anthony, if I may, just on the Summit of the Future, just to say, just a punt. On Friday, as DIRCA, we are participating in a civil society engagement, Friday afternoon, on the Summit of the Future that is being organized, I think, by the Open Society Institute or something. I'll send you the details. But it's Friday afternoon, but I take your advice. We will engage more with civil society in this regard.
Thank you. Thanks. Dr. Teller.
Oh, thank you, Chair. On behalf of the University of Johannesburg Institute for the Future of Knowledge, I would like to extend a heartfelt thank you to our esteemed chair, distinguished panelists, and all the participants for gracing us with your presence and insightful contributions in today's webinar. Your engagement has truly enriched our discussion and made this event a success. Let's continue to collaborate and drive positive change together. Thank you once again, and we look forward to seeing you in a couple of weeks for the second part of this webinar series. Goodbye.
The University of Johannesburg, the future reimagined.